Okay, good morning, everybody. I think we will get started as it has just gone 9:30. Thank you very much for joining us today. This is our annual contract law update webinar, and it seems like the last year has passed by in an absolute flash since Sophie and I last presented this update in December last year. But the Court of Appeal has had a busy year this year on the contract front and has provided us with plenty more material for today's session. For those of you who haven't joined us previously, my name is Rowan Turrall and I'm the Head of Dispute Resolution at Boyce Turner, and I'm joined by Sophie McDonnell, who is an Associate Chartered Legal Executive in the team. Now, as always, as litigators, we sit in the very privileged position of nitpicking about the wording of contracts after they've already been drafted and signed. And as a result, we just get to see what goes wrong at the end and not the fact that you've been trying to negotiate a clause at midnight the day before your year end when your sales director is breathing down your neck. But hopefully we can use our insight to provide some guidance today to help mitigate against some of the risks that can arise. And we're going to cover 4 topics from this year's cases today. We're going to start by looking at forming a binding contract through WhatsApp and email exchanges. And for that topic, Sophie is going to be looking at the cases of DAZN and Coupang and JV and Fincham. We're then going to move on to the incorporation of unusual and onerous clauses and what has been described previously as the red hand doctrine. And spoiler alert on that one, you're not supposed to call it that anymore, and I'll explain why when I get onto that one. For that topic, we've got 2 cases that the court has looked at this year, Durber and PPE Entertainment, which looks at it from a business-to-consumer perspective, and MS Amlin and King Trader, which then looked at the same question but in a commercial context. Next, I'm going to be looking at disclosure and barring services and Tata, purely in relation to the question of conditions precedent. And lastly, I'm going to be looking at exclusion clauses and the expression anticipated profits with the benefit of the Court of Appeal's decision in EE Limited and Virgin Mobile Telecoms. Today's session should last us about 45 minutes, but we've got lots to squeeze in. So we're not planning to answer questions at the end, but do feel free, please, to save up those questions and either insert them into the Q&A box and we'll follow up afterwards, or we'll also have our email details at the end of the slides. So please do feel free to follow up by email and we'll deal with those questions for you separately. We'll also be circulating a copy of the slides after the event, and we are recording as well. So if you need to drop off for any reason, we'll be sending around a copy of the recording and you can pick up at a later date. So with all of that as by way of an introduction, Sophie is going to start us off with the first 2 cases. So Sophie, over to you.
Thank you, Rowan. Good morning, everyone. I'm going to start by looking at 2 cases which deal with the modern day peril of WhatsApp messages, an issue which appears to be increasingly causing problems. The reason for including these cases is to serve as a reminder to you to remind those in your business that you don't need a formal written signed agreement to enter into a binding contract. The first of the 2 cases is DAZN Limited and Coupang Corporation, which was heard by the Court of Appeal in August this year. This dispute that arose was whether there was a binding contract between the parties which DAZN granted Coupang co-exclusive live and video on-hand demand broadcasting rights in South Korea for the 2025 FIFA Club World Cup. The matter initially came before His Honour Judge Pelling, who determined that a contract had been formed and found Coupang was entitled to specific performance of the contract. He therefore made various declarations and granted injunctive relief to protect Coupang's position. DAZN appealed, and the appeal was heard just before the competition was due to start. Before getting into detail, it's worth pausing to set out the principles which the Court of Appeal considered in relation to the formation of the contract, which were taken from the case of Smith Salvage BV versus Luster Maritime, and which can be summarised as follows. The whole course of the parties' negotiations must be considered. It is possible for parties to conclude a binding contract even though it is understood or agreed that a formal document will follow, which may include terms which have not been agreed. Whether this is what the parties intend must be determined by an objective appraisal of their words and conduct. The burden lies on the party asserting that a contract has been concluded to show that it has. In his judgment, Lord Justice Popplewell said, In construing written communications between the parties, it is important to recognise that business people conducting commercial negotiations will often not use the precision of language which lawyers aspire to in contract drafting. The language may be imprecise, ungrammatical, and impressionistic. Their communications must be interpreted by reference to the substance and sense of what is said, not by the kind of intense examination of the words, syntax, and grammar to which a contract carefully drafted by lawyers may be subjected. He also noted it will be relevant if the parties negotiate in a context where performance of an agreement reached is urgent. It is more likely that the parties will wish to be bound even though further details are to be agreed or a formal contract drawn up. The judgment cites numerous WhatsApp exchanges and emails between the parties, but essentially it came down to two emails. The first dated the 27th of February, which said, "John has asked me to send the proposal below, which captures our intention for acquiring the upcoming FIFA Club World Cup media rights this year." It then listed the requirements, which are shown on the slide. It then said, "We are very excited to land this new deal with you and eager to move on to the contractual phase so that we can start planning on content and utilisation." There were some further exchanges before the following email response of the 3rd of March. "I'm pleased to inform you that we will accept Copang's play offer for the FIFA Club World Cup 2025. We will start contract drafting and hope to share the draft for your agreement soon." There are a number of further exchanges over the following week or so, all of which broadly gave a flavour that the deal was going ahead. Some of these included chasing up a written contract. As ever, you can guess where the blame was placed for the delay. Shortly afterwards, though, it looked as if other individuals in DAZN were seeking to conclude a deal with another company. Ultimately, Copang did not get the comfort it wanted, and it applied to court for injunctive relief and specific performance. At first instance, this was granted. DAZN appealed, and the challenge on appeal was essentially day one contract law module principles: whether there was an offer, whether there was an acceptance, and whether there was an intention to create legal relations. There was 3 grounds of appeal, which we're going to cover today. Firstly, the 27th of February email did not amount to a contractual offer, but it did not objectively demonstrate an immediate willingness to be legally bound on acceptance. The 3rd of March email was not an unqualified acceptance. And finally, that there was no intention to create legal relations because any agreement was subject to contract, with the parties anticipating a formal agreement to be drafted and signed. Lord Justice Popplewell dealt with these grounds of appeal in his judgment. He applied the legal principles which I set out earlier and found that it was clear that the parties had reached an agreement they intended to be immediately and legally bound by the exchange of emails in question. The 27th of February email set out a summary of the deal terms. He felt that the email of the 3rd of March was intended to be a formal acceptance. There was nothing to suggest that the parties intended that the formal drafting of the contract was a necessary prerequisite to being legally bound by the agreed terms. The parties were therefore bound. This wasn't the only case this year, though, on contract formation through informal methods. Before pulling together the learning points and tips from the case, we're going to have a look through the case of Javee, Holmes and Fincham from April of this year to gain some more insights on the court's approach to this topic. Javee and Fincham was heard by Roger Tahar, KC, sitting as a Deputy High Court Judge. It was a construction case, and a large part of the judgment deals with the implications of the form of contract on the payment terms which were applicable. I'm not going to go through that part of the judgment, and instead will concentrate just on the part which deals with the formation of the contract. The claimant was a property developer and the defendant was a demolition contractor. The claimant approached the defendant to provide demolition services at a nightclub it was demolishing in Norwich. The defendant provided a written quotation by email on the 11th of May 2023. It set out pricing for 4 different sections of work. On the 17th of May, the following WhatsApp exchange took place. You'll see I've slightly shortened and it's set out on the slide. Just over a week later, the claimant sent over an email with a zip file of documents which included a purchase order, a short form subcontract, and marked up plans. When the parties subsequently fell out, it became key to ascertain whether the documents which were contained in the zip file formed the contract or whether it had been formed earlier. The case initially went to adjudication before the court as Part 8 proceedings, with various declarations in relation to the contractual position. The defendant's case was that the contract was concluded by the exchange of WhatsApp messages on the 17th of May. The claimant contended that as at that date, there were essential terms of the contract which had not yet been agreed. In the claimant's submission, an informed objective observer would not infer that the parties intended to form legal relations and a binding contract. The claimant's case was that although the defendant never acknowledged or replied to the email attaching the written subcontract documents, it was the last shot and contained the remaining essential terms which it said were missing as at the 17th of May. The judge found that while the exchange of WhatsApp messages was informal, it evidenced and constituted a concluded contract. The scope of the works had been agreed, the price had been agreed, and there were no express indication that the final terms of the agreement between the parties depended upon agreement as to any other matter, such as the incorporation of the claimant's standard terms of contract. On that basis, the claimant's subcontract terms were not incorporated into the parties' contract when it was concluded. In our day-to-day practice, we are often told that a client doesn't have a written contract. In their view, there is therefore no binding agreement. However, on closer inspection, there have been verbal discussions, email exchanges, WhatsApp and text messages, which when viewed together make clear that there is in fact a contract. Although picking out what is actual terms can be a complex process. The problem to be tackled with from an in-house legal perspective is ensuring that everyone in the business understands that they can form a contract with quick exchanges of messages. Unless they expressly confirm that the final terms of the agreement depend on you getting involved and putting everything into place, they could end up with a two-line contract complete with emojis. With informal methods of communication increasingly finding their way into regular business communication channels, it's an area of risk that needs to be understood within your business to help issues further down the line. It's not just in the everyday back and forth of what your business is buying or selling that you need to consider the risk. There is also the blind spot of contracts that may not be thought of as being contracts. You may have drummed into everyone that if you are signing up a new customer to your business, you have to get them to sign your standard terms and get it reviewed by legal if there is a pushback. However, what if someone is getting some repair work done to the office roof or agreeing to interview a candidate that a recruitment agent has put forward? Would they know what to look out for and make sure they don't cross the line in WhatsApp disaster? The further area of risk in relation to informal exchanges is what happens at the end if it all goes wrong. Formal written contracts can be misplaced, but you are likely to have a far more difficult job building your case if your starting point is piecing together a mishmash of WhatsApp messages and emails. Even if they don't amount to binding contracts, they may provide useful evidence of the matrix of fact which the court takes into account in the event of a dispute. If in spite of your best efforts, there is a dispute how the contract was formed, how can the business ensure that these communications are captured in a way that can be identified and referred to at a later date? This is particularly a risky area if key individuals have left the business, or if they have used a personal device or an account to send work messages, or if their phone falls off the side of a boat, as in Wagatha Christie, and all the messages are lost. What works is going to depend on your business model and the individuals involved, so we can't share a one-size-fits-all approach. However, we do hope that these points help you to assess where the risk for your business is most likely to lie, and you can try to mitigate those risks. I will now pass you back to Rowan to discuss incorporation of unusual and onerous terms.
Thanks, Sophie. So I am going to start by looking at two cases which this year have considered the incorporation of onerous terms. The first one is a High Court case, which was in the business to consumer context, and the second, a Court of Appeal case in a commercial context. That first case is Durber and PPB Entertainment, which considered a bet placed by the claimant on the Paddy Power online gambling site. Instead of winning the monster jackpot of just over £1 million on a wild hatter game, which was what had been shown on her screen, she was paid just over £20,000, which was the daily jackpot amount that day. The defendant told her that the reason for this was an error in the display which she saw on her screen. The animation she saw should have pointed to the daily jackpot, but because it had been mal-programmed, it did not. The defendant relied on its terms and conditions, which it said it was entitled to rely on, to refuse to pay the monster jackpot in these circumstances. You can understand why the claimant was understandably quite upset that she got 20,000 rather than her million, and the case progressed as an application by her for strikeout or for summary judgment. There were 5 issues identified by the judge for decision, but the only one that I'm going to look at today is the question of whether 2 clauses in the defendant's terms and conditions were incorporated, or were they not incorporated because they were unusual and onerous and were not adequately brought to the claimant's attention. By way of background, the claimant had opened her account with the defendant in 2011, and as part of the registration process, she confirmed that she agreed to be bound by the defendant's terms and conditions. The terms were available to be viewed via hyperlinks during that registration process. On the day that she played the game, the defendant accepted that an animation had shown her the monster jackpot. However, it asserted that it should have shown her the daily jackpot, and it relied on 2 of its clauses as a basis for not paying her. B1 was one of the clauses, the effect of which was that where there was a discrepancy between the result of the random number generator software that sat behind the game and the result that was shown on the screen, the record on the defendant's server was definitive. B2 was the other clause, which in summary said that where the result on the screen was an error that fell within the scope of the clause, the defendant was not liable for any payout and was entitled to avoid the play. Whilst the claimant accepted that the contract included the defendant's standard terms, she said that those terms were subject to whether each of them were incorporated and also subject to the Consumer Rights Act. I'm not going to cover the Consumer Rights Act elements today, as the court didn't need to address them in any detail, but for those of you dealing with business to consumer contracts, that's obviously an additional hurdle that you'll need to consider when you're looking at your terms. The claimant asserted that the defendant's terms ran to 44 pages of closely typed small print with numerous hyperlinks to other pages. Given the draconian nature of the limitation which the terms unilaterally purported to impose, effectively giving the defendant power to take away a prize which she thought she'd won, she argued no reasonable consumer could be expected to read and understand the terms without them having been expressly highlighted prior to the opening of their account and on each occasion that she used the website. She denied that any reasonable consumer would access the terms, much less understand them. The judge stated that the common law position is that for a trader to incorporate a particularly onerous or unusual term into a contract with a consumer, there is a requirement to use reasonable efforts to bring it to the consumer's attention. The words onerous or unusual are not terms of art, but instead are a way of putting the general proposition that reasonable steps must be taken to draw the particular term in question to the notice of those who are bound by it, and more is required in relation to certain terms than to others depending on their effect. There's a high hurdle, but as ever, it all depends on the context, the facts, and the nature of the contract. In this particular case, the judge's starting point was that B1 was a conclusive evidence clause, and in this case it was onerous, and that B2 was unusual and onerous. Having found that, he then moved on to consider whether those clauses were reasonably brought to the claimant's attention at the time the contract was made. Some of the factors that the judge took into account when making that decision included the following. The clause was not entitled exclusion of liability for our mistakes. It wasn't listed in the index to the terms of use. It wasn't in bold or in capitals or highlighted. It was in the middle of 45 pages of small print. It wasn't referred to on the screen when the claimant started playing on the day or at all. The written contract terms were set out in multiple differently located documents, which made it difficult for consumers to see the whole contract in one place. The defendant didn't print them in big red letters or put a big red hand or a finger pointing towards them. They didn't put a warning or a notice on any pre-contact screens or on the jackpot screen, and they didn't put the clauses in a bold box or put the text in capitals. In light of the above factors, the judge found that the defendant had failed reasonably and sufficiently to bring clauses B1 and B2 to the claimant's attention, and at common law found that the clauses were not incorporated. So that's a case in which the clauses were looked at in a consumer contract were found to be unusual and onerous and not brought to the consumer's attention. So I'm going to look at another case now dealing with the business position before pulling together some thoughts on how they might affect you in your day-to-day contract reviews. So the second case is the case of MS Amlin Marine and King Trader, and it was decided by the Court of Appeal just last month. And it's a case concerning the interpretation of a marine insurance policy. So for that reason, I'm not going to go into any great detail about the background of it, as we look at the principles without really understanding what was going on from the insurance side of things. Instead, I'm going to look at what was headed the red hand ground in the judgment. And this particular issue centred around what's called a pay first clause in the policy, which was relied on by the insurer. The clause essentially provided it was a condition precedent to the insured's right of recovery under the policy that it should first have discharged any loss, expense, or liability. It was argued that that clause had been buried in a section of the general terms and conditions and so should not be given effect. The appellant relied on a principle of interpretation that it said that where terms were incorporated by reference, a particularly onerous term was not to be given effect unless the other party's attention had been specifically drawn to that term. So Geoffrey Voss therefore started by reviewing the previous case law to determine the origins of this principle. And he pointed first of all to the judgment of Lord Denning in J. Spelling Limited and Bradshaw from 1956 as effectively being the genesis of this principle. In that case, Lord Denning said obiter, some clauses which I have seen would need to be printed in red ink on the face of a document with a red hand pointing to it before the notice could be held to be sufficient. There then followed some subsequent cases in which this principle was mentioned or was applied in some form, some of which you may recall from the recesses of your contract law training. Thornton and Shoe Lane Parking was the next case which popped up, and this was an exemption clause which was not incorporated into a car parks contract. Again, Lord Denning's comments were obiter, but he said that in order to give sufficient notice, it would need to be printed in red ink with a red hand pointing to it or something equally startling. You'll see that no expense has been spared in my red hand animation there. You'll probably also recall the Interphoto case, which was the next one that Sir Geoffrey Voss referred to. And in that case, it was Lord Justices Dillon and Bingham who applied a version of the red hand doctrine, but they disagreed as to the basis for the principle. Lord Justice Dillon's view was that an onerous clause never became part of the contract, whereas Lord Justice Bingham thought the party was relieved of liability under the onerous condition. Lord Justice Bingham did, though, comment that to the extent the conditions were in common form or usual terms in a particular business, he didn't think that the defendants could contend that they were not incorporated. The next case that came up was a much more recent case of Good Life Foods and Hall Protection from 2018. And in that case, an exclusion clause was found not to be onerous or unusual and had been fairly brought to the purchaser's attention. However, the case recognised the principle that a condition which is particularly onerous or unusual will not be incorporated unless it has been fairly and reasonably brought to A's attention. However, the court also recognised that between parties of equal bargaining power, party autonomy is a cornerstone of English common and commercial law, and parties are free to allocate risk as they see fit. The case therefore demonstrates the uphill struggle in relying on the principle where parties are of broadly equal bargaining power, and the clause is one which is in common use in their field of business. Bates and Post Office number 3 was also mentioned briefly, in which Fraser said that the more onerous and unusual a clause, the greater notice must be given to the other party. In the context of commercial contracts in particular, he said that the principle is available to contracting parties who are not consumers, but context and the respective bargaining positions of the parties are relevant. I also consider that it is a high hurdle that must be passed for a term to be held to be onerous and unusual. So having gone through a run-through of that previous case law and considering how the principle had arisen, Sir Geoffrey Voss concluded that there was a red hand doctrine. But then he killed off that name in his next sentence, deciding that Lord Denning's reference to a red hand should be no more. He said that the name the red hand doctrine is unfortunate and should not be perpetuated. and instead he decided it should be better described as the onerous clause doctrine. It doesn't have quite the same visual imagery as the red hand, but he encompassed the principle as follows. Where a particularly onerous or unusual term of a contract, an onerous clause, is contained in one party's standard terms, and where the other contracting party does not actually know of that term, it will not bind the other contracting party unless the party seeking to rely upon it shows that the clause in question was fairly and reasonably brought to the other party's attention. Both the question of how onerous or unusual a clause needs to be and the question of what amounts to a fair and reasonable notice are questions of fact and degree that the court needs to decide, taking into account all the circumstances of the case in question. He said that the doctrine can be applied to both consumer and commercial contracts, but there's a high threshold to establish that a clause is onerous or unusual. Importantly, he said that the doctrine is unlikely to have any application to commercial contracts where the parties are broadly equal bargaining power and where the clause is in dispute as common form or usual terms regularly encountered in the business. So pulling through those principles that were touched on in the previous cases. Applying all of this to the clause in question, he found that the judge was right to decide that the clause was neither onerous or unusual. This was a commercial contract between parties of broadly equal bargaining power in which the court should be slow to intervene. He also found it was not unusual for clauses of this type to be encountered in marine insurance, and although it had a serious and significant effect, it did not, in his view, reach the high threshold required to make it onerous. He stressed that not every burdensome clause is going to be onerous. Arguing that the clause was hidden away also didn't help when the insured was represented by a professional marine insurance broker. Sir Geoffrey Ross ventured to suggest that the doctrine would never be applicable where a party had its own professional broker or advisor. So pulling the threads together from those two cases, the extent to which they're going to impact you on a day-to-day basis are really going to depend on whether you're primarily dealing with consumers or businesses, having far more of an impact on you in the former rather than the latter case. Don't forget as well that if you are dealing with consumers, you're also going to have to battle against the principles set out in the Consumer Rights Act. You'll need to make sure that your terms are easily accessible and easy to digest, and that any clauses which might be considered to be onerous need to be clearly worded and clearly flagged if you're going to have any hope of getting through the case law. If you're mainly business to business and you're generally contracting on your own standard terms, then broadly speaking, you're going to find that the other contracting party is going to have a pretty steep mountain to climb if it wants to argue that a clause is one that should be considered to be unusual or onerous. It's not impossible though, so it's still worthwhile ensuring your terms are clearly set out, easy to access and easy to review. On the other hand, if you are going to be contracting on another party's standard terms, then again, you're going to really struggle to build a case using the onerous clause doctrine, particularly if you're dealing with a party where you're of equal bargaining power. And again, this is really most likely to cause you problems in those contracts which sneak past you and are dealt with by others without coming in for legal review. So it could be that contract for an order for new mobile phones the entire workforce that the IT director signed up to, or again, maybe the HR director signing up to terms with a recruitment agent. And there's something really objectionable lurking in those terms that you end up stuck with. Because although it's burdensome, it doesn't meet that threshold of being an onerous clause that's not being drawn to your attention. Whether you're business to business or business to consumer, you do need to make sure that you keep a really good audit trail of your terms. And this is really a wider point to bear in mind beyond just the onerous terms doctrine. In the Derby case, the defendant had lost the copy of its 2011 contract, which had existed at the time, and it also couldn't produce any evidence of the customer notice, which was supposed to have been sent out later on when it changed its terms in 2020. It's worth remembering that if you rely on the incorporation of terms via your website, it's really important that you keep copies of each set of terms when they're updated so that you can refer to whichever set of terms were applicable at the time at which they were incorporated. All too often, we advise clients where terms have been updated online, but there's been no clear referencing. Nobody can remember or find any evidence of when they were actually changed or which versions of the terms would have been visible on the day that the contract in question was concluded. Also, another wider point, but one that was touched on, as mentioned, in the Derby case, If your terms provide for you to be able to amend them by sending out a notice to customers, again, it's vital that you retain evidence that you've done so. Quite often, we're provided as the evidence a template generic set of wording, which is supposed to have been sent out to all customers to advise them of changes, but the client's got no way of actually evidencing which customers received the notification at the time. You therefore need to make sure that when you're making those sorts of changes, whoever is responsible for sending out those types of update is able to put in place an appropriate paper trail to show who has actually received the notification, and that information is subsequently available in an easy and accessible way for you. So next, I'm going to move on to the case of EE Limited and Virgin Mobile Telecoms, which is actually a case that we discussed in one of our previous updates in terms of the first instance judgment, but it came back before the Court of Appeal earlier this year. The issue that was at stake in the Court of Appeal was whether the sums that were claimed by EE for breach of contract were anticipated profits and so excluded by a limitation of liability clause between the parties. To give you a little bit of background, EE issued a claim against Virgin, arguing that Virgin had breached an exclusivity clause in the agreement between the parties and was so liable to pay damages. Virgin denied the breach, but also argued that in any event, the losses would be excluded by a clause which excluded liability for loss of anticipated profits. The parties had entered into an agreement by which Virgin contracted with EE to make use of its mobile network, and this was originally for 2G, 3G and 4G services, but later on it was amended to take into account 5G services being provided. When EE then launched its 5G services, Virgin was unable to reach an agreement with it, and it entered into an agreement for the provision of 5G services from Vodafone instead and started to migrate customers to the Vodafone network. EE argued that this was in breach of the exclusivity clause because it also migrated non-5G customers to Vodafone, or that new non-5G customers were added to Vodafone rather than to EE. EE framed its claim as damages for just under 25 million for loss of revenue claimed as damages, and it argued it had been deprived of the revenue that it otherwise would have earned. It also described its claim as being for charges unlawfully avoided. Virgin argued that this was essentially a loss of profits claim by another name and was clearly excluded by clause 34.5, which I've included on the screen. Virgin made an application to the High Court and asked that it grasp the nettle and deal with the interpretation of this clause as part of a summary judgment or strikeout application, rather than leaving that matter to be addressed at a trial. At first instance, the judge found the claim in question was a claim for loss of profits, and that to suggest otherwise appeared to be fanciful. She considered whether the clause in question excluded that claim, and she found that on a true interpretation of the clause, any liability on the part of Virgin for the unlawful diversion of customers to alternative networks fell within the scope of the clause. Given the sums at stake, it's perhaps not surprising that EE appealed the decision on the basis they considered the judge was wrong to characterise the claim as one for loss of profits rather than a diminution in price. Essentially, the question was whether loss of profits meant something other than loss of the value to EE of the contractual performance it would have achieved but for the breach of contract. There were three overarching agreements which EE made in support of its appeal. Firstly, on the judge's construction, exclusion of liability for the loss of profits was capable of obliterating virtually every claim to recover expectation loss, and the courts have repeatedly held that not every claim for expectation loss falls within such a clause. Next, they argued that the wording of the clause favoured a narrower construction than anticipated profits, because that meant profits that were anticipated to be earned outside of the contract. Lastly, they said the commercial consequences of the judge's construction of the clause left EE without a meaningful remedy for the breach in question, and so that should lead the court to a narrower construction of the clause. Lord Justice Zaccarelli gave the leading judgment and dismissed the appeal, and he summarised his reasons for doing so as followed. He said there's no overarching principle that limits an exclusion of liability for loss of profits to losses other than expectation loss or diminution in value. He not very helpfully, in my view, noted that in some cases similar wording has been found to be limited in that way, and in other cases it hasn't been. However, this wording, he said, was clear and unequivocal. He said that the better reading of the clauses was that liability for anticipated profits was intended to mean something additional to loss which doesn't arise directly from performance of the agreement. If the parties intended it to cover only direct loss of profits claims that are not within the ambit of expectation loss, they would have done so specifically. The clause is part of a lengthy contract which had been drafted with the assistance of legal advice with risk allocation between the parties. And lastly, he felt that the consequences of the clause were commercially reasonable. However, this wasn't a 3-0 victory. Lord Justice Phillips was not as convinced. In his judgment, the loss was to be regarded as a readily ascertainable sum that would have been payable for the services as the contract price, but for the breach. In his view, anticipated profits was meant to cover hoped for but uncertain profits which would arise as a consequence of, but outside performance of the contract. It didn't cover sums directly payable under the contract, and he therefore would have allowed the appeal. Fortunately for Virgin, Lord Justice Coulson sided with Lord Justice Zaccaroli and also dismissed the appeal. However, he did say that he'd found it not an easy case to decide. His first instinct had been that allowing the clause to exclude a claim for sum which would otherwise have been due under the contract was not correct, as it would strike at the heart of the bargain between the parties. However, he was persuaded otherwise, and part of his reasoning was he could have framed its case to separate out the claim for wasted expenditure, which he thought would not have been captured by the clause, from the claim for loss of profits, which would have been caught. So there we have a result, a 2-1 in favour of dismissing the appeal, but only just. And it just shows the difficulties around the interpretation of anticipated profits in a clause of this case, this type. And it's worth noting that Lord Justice Coulson commented that the cases that have been relied on by E to back up their position was something of a rag bag of particular results in particular types of cases. He went on to say that these decisions always come down to the words used and the commercial background on which the words must be construed. So other cases are always of limited utility. And I appreciate that in your roles, that's not something that you want to hear, because the chances are if you come to a litigator to ask them what a clause means, they're probably going to say it depends. It does highlight, though, how difficult it can be to decide precisely which words to use when you're drafting an exclusion or limitation of liability clause. What works in one scenario isn't necessarily going to have the same effect when set in a different context. So the things to think about, but not really kind of an extensive or exhaustive list of things that you can take into account. But I find it might be helpful to think carefully about what is most likely to happen if it all goes wrong. If a claim is brought against you because you are alleged to have breached the contract, what type of losses are your counterpart most likely to suffer? Likewise, if you needed to bring a claim, how are you most likely to be impacted by a breach? There are so many scenarios in which your losses could ultimately be described as loss of profits that you need to be really alive to this if that wording is included in your clause to see how it might impact you and whether you need to adjust your wording to take anything into account and carve anything out. If you work backwards from what might go wrong, it may help you to work out whether a clause is likely to capture something as well that you don't intend it to capture and adjust your wording accordingly. However, don't forget that clause will be applied in the same way to all breaches unless you use express wording. If there is a particular subset of loss that you really want to be able to claim damages for, or if you really want to make sure is excluded, there's always a balancing act to be had when you're negotiating. Whilst clear drafting is probably going to help you in court, if you spell something out too clearly when you're drafting and negotiating, you might find out that the amendment is rejected or that there's a trade-off to be had elsewhere, and you might think you're better keeping quiet and hoping that somewhere down the line, the interpretation that you want it to have is the one that is favoured. But that obviously bears the risk of litigation further down the line if the position is left more ambiguous than it otherwise might be. You therefore need to balance up what the respective risks are of each approach and consider whether it's a risk that's acceptable. Also consider how certain less clear wording might still result in an interpretation in your favour and how strong you are in your view on that position. Don't forget, though, that the court won't look at what you intended the clause to mean, but instead what the objective meaning of the wording is when used and when set in the admissible context. And lastly, as ever, remember that the court is going to be slow to intervene if your wording is clear, which may or may not work in your favour. Even if the result is commercially disadvantageous for one party because they might not have thought through all of the scenarios, the court is going to be slow to intervene and won't necessarily come to the rescue from a bad bargain. So last of all, I'm going to discuss the case of Disclosure and Barring Services and Tata Consultancy, which was heard by the Court of Appeal earlier this year. And I've chosen to highlight this for some of the issues which can occur in conditions precedent. The underlying claim I don't need to go into huge amounts of detail about, but it essentially was a dispute about the introduction of a new system to modernise the disclosure and barring process and to replace the previous paper-based regime with a digital one. As you can anticipate, the project hadn't really gone very well, and it ended up with a claim for some £125 million one way, but a counterclaim back the other way of £100 million or so. It was a massive dispute which took a full term to try, but ended up with a net payment by DBS to Tata of just under £5 million. And a footnote in the Court of Appeal's judgment noted that the first instance judge had described TCS's claim as largely unmeritorious and DBS's counterclaim as large and unmeritorious. Leave to appeal was given on a single issue from the judgment, and Lord Justice Coulson described that first instance judgment on giving leave to appeal as magnificent. The appeal concerned clause 6.1 and whether that created a condition precedent, breach of which would prevent DBS from recovering just over £1.5 million, which it had claimed as delay payments, which it said were otherwise payable in accordance with that clause. I've popped clause 6.1 on the screen. I'm not going to read it out, so have a look through that. It moves on then to clause 6.2, which is quite a long clause. So again, I've not included it, but essentially it set out three options that might apply in the event of the clause applying. And one of those was a requirement for delayed payments to be paid. At first instance, the judge found that DBS was not entitled to the delay payments because payments under clause 6.2 were conditional upon DBS complying with 6.1. You'll note in the wording of clause 6.1, there is a requirement for a non-compliance report, and it hadn't issued any non-compliance reports at all. Lord Justice Coulson agreed with the first instance judge that it was a futile exercise to endeavour to articulate an exhaustive checklist of the factors to be considered. So I'm sorry, I cannot give you a tick box that you can run through to help you decide if a clause is condition precedent or not. However, there were some general principles from the case law which I have summarised. First of all, whether or not a party has to comply with one or more stated requirements for being entitled to relief will turn on the precise wordings used within their contractual context. A condition of precedent, as the name suggests, needs to be something that makes the relief conditional upon a requirement. Clear words will usually be necessary for a clause to be a condition precedent. However, he did say that it's not necessary for the clause to say in terms, this is a condition precedent. In addition to conditionality, it will usually be necessary for the link between the two steps to be expressed as an obligation, e.g. shall, but on its own, that won't be sufficient to amount to a condition precedent. It's not necessary for the step one condition to be expressed within a finite number of days or weeks. Phrases such as timely or within a reasonable time have been included in clauses which have previously found to be conditions precedent. Having looked at the words in their context, Lord Justice Coulson determined that the words in clauses 6.1 and 6.2 were sufficiently clear to amount to a condition precedent. They were expressed in the conditional. They left the reader in no doubt that 6.1 had to be fulfilled before steps in 6.2 could be exercised. And the failure to provide a non-compliance report was therefore fatal to the claims for delayed payments. Lord Justice Lewison also gave a judgment, and he set out in more detail in his judgment a way of reviewing conditions precedent that I think is a useful way to approach matters when you are drafting. And that is to use a sentence structure, which is if, then. The then part of the sentence is not reached unless the condition introduced by the if is satisfied. He borrowed from the decision of Lord Justice Oliver in the case of Freehold and Leasehold Properties Limited and Friends Providence Life Office, and he described DBS's interpretation of the clause as being difficult to resist the conclusion that it is not simply a matter of construction, it's demolition and reconstruction. So instead, if you approach it from the if-then analysis, he referred to negative conditionality instead as being a similar approach, being unless and not. This was simply another way of expressing conditionality. Lord Justice Lewison also felt that the absence of a fixed time limit was not incompatible with a requirement being a condition precedent. He came up with the phrases as soon as possible and within a reasonable time as both being other cases in which conditions had been found using that wording. And he therefore agreed with Lord Justice Coulson in dismissing the appeal. So I'm going to wrap up that last case with looking at some principles that you might be able to draw from this case to help you either when you're drafting conditions precedent, but also really important to think about when they are being operated. First of all, it may sound extremely basic, but think very carefully whether you actually want a clause to be a condition precedent. Is that actually going to favour you or is it going to hinder you? If you don't want it to be a condition precedent, then be very careful about the language that you use to avoid imposing that conditionality. If you do want to introduce a condition precedent, then try to keep it simple. Make sure your wording is clear and keep it precise. You need to be able to understand clearly what the trigger is and how and when it is going to be triggered. As I mentioned, using that if, when, or unless not sentence structure may help you on focusing to get the structure right. Think as well about the timing. The case has made it clear that you don't need to give a fixed timescale. But if you don't give a fixed timescale, what wording are you going to use instead? And would you prefer for there to be a fixed timescale, which can give you certainty, or prefer to use a wording that would give you some flexibility? Also have a think about what needs to be done to fulfill the condition and how quickly it's likely to be done in practice. If the guys on the ground tell you that it's going to take them weeks to do whatever is needed to trigger the condition, don't put in a timescale of 5 days to trigger it. Once you've got your contract in place, make sure everybody is alive to the need to have one eye on that condition precedent. If it's your company's responsibility to fulfill the condition, you need to find a way to ensure that those at the coalface know what they've got to do and when. And that knowledge needs to be embedded well. So if people move on a project that's a long-term project, that knowledge doesn't leave with that individual and is lost. So if, for example, there's a requirement to submit non-compliance reports when certain events happen, and without that, you're not going to be able to claim damages or have some other remedy, then you need to make sure there's a process in place to remind the team of the need to submit that report, particularly when there's a fixed timescale. Think about where that requirement gets recorded in practical terms to make sure that you don't fall foul. Lastly, make sure that everybody knows what to do. And as I said, if they think that it's going to be impossible to actually fulfill a condition in practice, make sure that the team give you some practical input into what they need to be able to do and how they think it should be done. So I'm conscious that we have just run a couple of minutes over what we said, but you'll be pleased to hear that does conclude today's session. The key takeaway point really from the cases this year, and we've had fewer that dealt with contractual interpretation than previously, is the court is continuing to take a robust approach to interpretation. Where you are drafting a contract with the benefit of legal advice, you've used clear wording to allocate risk between commercial parties, the court is going to be slow to intervene to rescue you from the bad bargain. My first head of team, when I started out, always used the phrase, say what you mean and mean what you say. And I think it's a worthwhile mantra to have at the back of your mind when you're drafting as you move into 2026. Thank you again for joining us. We hope you found it to be a useful session. Please do get in touch with us, whether that's in relation to any questions that you've had on today's sessions or the cases, or you've got any general dispute or contractual issues that we can help you with. You've got our contact details on the slide, so please do reach out to us. Please also do keep an eye out for the other events that we run for our in-house community. We do run a lot of events throughout the year, and we're planning another exciting series of events for 2026, at which I hope you'll be able to join us. We also provide updates on LinkedIn, so if you're not already connected to Sophie and I, please do feel free to accept our connection requests. So that finishes for today. Thank you very much for joining us, and goodbye.